Major breaking news out of the Supreme Court. In a blockbuster opinion, the court outlawed affirmative action in college admissions. That means that universities can no longer consider race when looking at applications.
It was a 6-3 decision written by Chief Justice John Roberts, and that ruling overturned almost 50 years of precedent. Now, universities and colleges are scrambling to revisit and revise their existing practices and policies. NBC News correspondent Julia Ainsley joins us now from just outside the Supreme Court there in Washington. Julia, I know you've been following this case from the beginning, and let's be clear, this is a big deal. This is the most significant decision half a century on the use of race in college admissions. It affects lots of families. Tell us what this actually means in terms of kids who are applying to college.
Yeah, you're right. Well, it's a huge decision. Affirmative action as we know it has ended. That means for college applicants, they will no longer be applying to a college where the college sees on a piece of paper their race. Now, what Justice Roberts did say in his majority opinion, though, was that they should feel free, applicants should feel free to talk about how race has impacted their lives. He says if it has been a matter of, if it has been discrimination, inspiration, or otherwise, if that's how they found their courage, if that's what made them who they are, they should be able to talk about that on their college application. Also, we've seen a lot of people responding, including Governor Ron DeSantis of Florida, former President Trump, saying, look, it should all be meritocracy. I do want to emphasize that this decision does not simply put us in a place where we're taking the top test scores. In fact, the justices here always said diversity was something that colleges should be able to try to garner across their student bodies. What they're saying today is that race should not be the only factor, and they left the door open to try to look at other ways that they could make racially diverse and socioeconomically diverse student bodies.
All right, Julia, so you're saying that students still can talk about this in their applications, in the essays. Explain to us what the justification was for the majority here in making this decision. You look back to 2003 when there was a ruling related to University of Michigan Law School and whether or not they could consider race in the context of trying to have a more diverse student body. Justice Sandra Day O'Connor, in the majority opinion back then, 19 years ago, suggested that that type of ruling might not be necessary in 25 years. Was time used to argue why they made this decision?
You know, they didn't. In fact, what they said is that UNC and Harvard simply went too far in their admissions programs. And it's not just going to apply to those two schools, of course, because so many public schools follow a similar model as UNC and so many private schools follow the similar model as Harvard. And so this will apply around the country. And, you know, what they're saying here is that when you look at race, even though, you know, we're not at a place where we necessarily were any different than we were in 2003, what they are showing here is they say it goes too far and it violates the Equal Protection Clause under the 14th Amendment by looking at race specifically.
Now, I mean, Julia, this is really interesting because sort of in handing down this decision, this is where we saw some of the most spirited arguments from the court, right? Especially when they were questioning the lawyers from Harvard. And this is interesting because Harvard, we've got a private university, UNC, we've got a public university, and experts say that this decision basically ensures that the student bodies at elite universities in this country are about to become a lot more white and a lot more Asian and a lot less black and a lot less Latino. What do the dissenters say?
Well, it was interesting. We saw from Justice Jackson, who, by the way, had to recuse herself in the Harvard decision because of her affiliation with Harvard. But she did write a dissenting opinion in the UNC case and said that deeming race irrelevant in law does not make it so in life. Although formal race-linked legal barriers are gone, race still matters to the lived experiences of all Americans in innumerable ways. And today's ruling makes things worse, not better. We also saw a dissenting opinion led by Kagan as well. I'm sorry, led by Justice Sotomayor, Kagan agreeing with Sotomayor. These justices saying today what the majority has decided is going to make things worse.
Our thanks to Julia Ainsley there outside of the Supreme Court. Julia, as always, we appreciate it.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.